Welcome, everyone. We'll give people just a minute to join us. All right, welcome everybody. I think we'll go ahead and get started. Thank you so much for being with us today for this conversation. For those who don't know me, I'm Jennifer Mnookin, and I'm the Dean here at UCLA Law School, and I'm really delighted to welcome you to the first in a series that we're doing on the front lines. In this series, we're aiming to bring to our community a series of virtual panels that draw on the expertise of our faculty and alums to take a close look at legal questions and societal implications of some of today's most pressing issues. And we're really thrilled to have a fantastic set of panelists with us today to talk about obviously a very recent Supreme Court decision and what that's likely to mean in the short term and beyond. So we're very pleased to have you with us, both those of you who are alums and others, and we hope that you learn from and enjoy this conversation. I also want to give particular thanks. We were going to have some introductions from Alicia Mañana. Technical problems got in the way of that, but I want to thank her in particular because in part thanks to her generosity and that of her spouse, we're launching at UCLA an immigration center. And we're thrilled to be able to be taking our strengths in this space to the next level, given the tremendous ongoing importance of these immigration issues. So Alicia wasn't able to join us to do introductions, but she's out there in the audience. So I want to give her a wave and a shout out and to say thank you so very much. And then I want to do very quick introductions of our three panelists, and then we'll get started. You can feel free. The panelists are going to have a conversation, but we're going to save some time for your questions as well. Excuse my dog in the background. Welcome to our Zoom life, right? Please feel free to use the Q&A to ask questions. I can't promise that we'll get to all of your questions, but as moderator, I will direct some of those questions to our panelists. So please feel free to propose them, and I will be keeping an eye on that. So to move ahead with our introductions of our very distinguished panelists, first I'd like to introduce Jennifer Chacon. She joined us here at UCLA Law School in 2018. She'd previously been a professor at UC Irvine, and she's a leading expert in immigration law, constitutional law, and criminal law and procedure, and has written extensive scholarship on citizenship, immigration, border control, the criminal law immigration intersection, and human trafficking. And it's just such a pleasure to have her on our faculty and to have her here speaking today. We're also joined by Professor Hiroshi Motomura, who came to the law school in 2007. He's also taught over the course of his career at both the University of Colorado and the University of North Carolina, but we've been thrilled to have him with us for the past 13 or so years. He's the Susan Westerberg Prager Distinguished Professor of Law, and he too is a leading voice on immigration. In fact, he's written several acclaimed books on the issue, and they're if you're not an immigration law expert, they're pretty readable. So I would encourage you, if you want to know more about how we think about immigration and citizenship in this country, his books are really go-to sources on that. And in fact, he's been a resource for policymakers at the local, state, and federal level, and in 2017 was one of the only law professors to receive a Guggenheim to pursue his research. And I'm very pleased to announce that he will be our inaugural faculty director of our new Immigration Law Center. Yes, exactly. This is you on this call are among the first to learn this news, and we're thrilled and excited by it. I'm also delighted to introduce Dan Sharp. He's a 2004 graduate of the David J. Epstein Program in Public Interest Law and Policy here at UCLA Law School. Until earlier this year, Dan was the longtime legal director of the Central American Resource Center, CARECEN of California, where he guided immigration policy advocacy. Now he's a few months into a new job as the chief of the Office of Immigrant Affairs at the City of LA Department of Consumer and Business Affairs. So thank you so much, Dan, for joining us for this conversation. Without further ado, let's move on to our substance, to think about DACA and beyond. Again, thanks so much for being with us. We've got more than 150 people with us today, and we just announced this a few days ago, so we're thrilled to have you. I think we want to start with some nuts and bolts and some basics about DACA and what it is and what it means and about this opinion. So Dan, I'd love to turn to you first to just give us an introduction about DACA itself. Could you tell us a little bit more about what DACA really is?
Sure. Thanks so much, Dean Mnookin, and thank you for the invitation. Great to be back on campus, albeit in the virtual space. To tell the story of what DACA is, I think we have to spend a minute thinking about how we got there. And so there's really two parts to the story. And the first part is that of dreamers, individuals who were brought to the US as children and really knew no other country as their own, beginning to tell their stories, their successes, their dreams, their plans for the future, and then the barriers that they encountered due to their lack of immigration status, despite being American in really every way except a birth certificate. So as dreamers started to tell their stories, we saw Congress begin introducing legislation to respond to this issue as early as 2001 and to provide them a path to permanent residence. But the other part of the story is that despite strong public support in public polling, going back to the early 2000s for providing a path to permanent residence and eventual citizenship for dreamers, we saw the failure of Congress to resolve the issue for many years, not only in 2001, but for over a decade. Most notably, in 2010, we saw lest we think of this as a purely partisan political issue, the House, Senate, and White House, all controlled by the Democrats, the House of Representatives passed the DREAM Act in December, and then the legislation had majority support in the Senate, but could not garner the 60 votes necessary to break a filibuster to get the legislation to the floor for a vote, with 6 Democrats standing in opposition to the bill. And so fast forward a year and a half, as the President Obama was in a election campaign, we saw mounting pressure from dreamers who'd grown increasingly vocal and sophisticated in their organizing and advocacy, really losing their fear of revealing their lack of immigration status, and pressure mounting on the administration to address their plight. And so we saw in June of 2012, the administration, through executive action, create the DACA program. And so the legal justification was the exercise of prosecutorial discretion, but rather than applying it reactively when dreamers would be encountered by immigration authorities, the administration created sort of a categorical program where people could come forward and apply affirmatively to receive 2-year reprieve from deportation and work authorization during that time, along with a right that comes with a work permit to a social security number, and then corresponding benefits like a driver's license. The program also created the right to travel in limited circumstances, called advanced parole, but importantly, no path to permanent residence. And then the program, the nuts and bolts are that individuals to qualify had to have come to the US before age 16. They had to have been in the country for 5 years continuously on the date of the announcement of the program, and then be in high school or have graduated from high school or on a path to doing so. And then the administration created some age criteria. So no one who was over the age of 30 on the day of the announcement of the program in 2012 would be eligible. And then individuals, with one very limited exception, had to have reached the age of 15 in order to apply. And then the administration also created some restrictions based on criminal history. And so the application period opened in August of 2012. It was celebrated in immigrant communities around the country, and then roundly attacked by nativist and immigration restrictionists and their advocates in Congress, who criticized the president for exceeding his authority, alleging that he had engaged in an end run around Congress to enact an administrative amnesty, so to speak. And so this, as we'll discuss, I think later in the hour, this was really a transformational moment in the immigrants' rights movement with huge implications nationally and locally. Ultimately, about 850,000 people came forward, applied, and received the benefit from 2012 until the fall of 2017, when the administration took steps to end the program. About a quarter of those individuals are Californians, and the LA metro area is the largest concentration still of DACA holders, with over 80,000 individuals with DACA living in the greater LA metro area. And so I'll wrap up just by noting that the administration, the Obama administration, took steps in November 2014 to expand the program and create a comparable program for parents of US citizens and permanent residents who met certain criteria. And that effort was blocked in the courts. And I think with that, I'll pass it along to Professor Chacon to discuss the time frame of litigation that followed.
Thank you so much.
Go ahead, Jennifer. Tell us a little bit about the timeline.
Will do. So thanks. So I'm going to actually share some slides with you. If you can see them, I hope you can. You are all enjoying the benefits of my pandemic insomnia. So I wanted to just talk a little bit about the background, and Dan's already hit a lot of the high points. I wanted to highlight a couple of things that he didn't mention, just because I think they're interesting to give us a full picture of what of the narrative around DACA. Like Dan, my timeline here starts in 2001 with Congress failing to pass the DREAM Act. And that really should already tell you that the story didn't start there, that there was already enough activism underway to pressure members of Congress to introduce this act to give citizenship to certain young long-term residents. And when that act failed to pass, it was distressing, and it was part of a broader failure of immigration reform in 2001, sparked by, among other things, the attacks of September 11th. But there were still legislative successes in this time, and I wanted to just mention one, which is during the same year, activists were able to push for the enactment of California's AB 540, which provides in-state tuition and access to state financial aid for qualifying California residents, regardless of their immigration status. And this not only helped undocumented students to access higher ed, but also, as our colleague Lexi Abrego in Chicano Studies has noted, provided an umbrella for further organizing and activism in California colleges and universities. So it was an important kind of moment for this work. And these young activists then played a critical part in efforts to organize huge marches in 2006 in support of federal immigration reform that would have had a DREAM Act component. But as we've heard, Congress failed to enact this reform. President Obama ran on a promise to enact immigration reform in his first year in office. That didn't happen. And what we did see was Congress not enacting reform, but continually increasing funding for immigration enforcement. And the Department of Homeland Security implemented the Secure Communities program nationwide, which fully integrated state and local law enforcement into the federal immigration enforcement process. And so this is important backdrop for DACA, because what you can see from this slide here, if you look at the red bars, is that kind of looking around 2008, 2009, 2010, 2011, you see that people are being deported or removed, I should say, from the interior at record numbers. And the numbers of border removals are also hitting record numbers during this time period. And so the individuals who were advocating for the DREAM Act are living in a reality where not only is Congress not enacting legislation to protect them, but at the same time, enforcement efforts in immigration are ramping up substantially, making their situation and the situations of their communities much more difficult. And this, I think, really helps to push home the need for something that's protective. And so you do get, as Dan said, the announcement in 2012 by the Department of Homeland Security Secretary Janet Napolitano of the DACA program. And you had some litigation challenges to DACA. So there were some lawsuits that were filed. They all failed. And so the efforts to argue that DACA was illegal went nowhere during this period. And I think that's also really important to highlight. And then, as Dan said, in 2014, the administration attempted to expand that program by expanding DACA. Here on the slide, I call it DACA Plus, right? They tried to expand DACA by lifting the age cap that Dan mentioned, the 30-year-olds and older who had been barred from the program. They tried to make the period of deferred action last longer before you had to renew. And they also announced DAPA, which would have covered certain parents of US citizens and lawful permanent residents, but quite controversially, not the parents of DACA recipients. Texas, along with several other states, many other states, successfully sued to stop this program from going into effect. So the DACA expansion and DAPA were enjoined by a federal district court, and that injunction was upheld by the Fifth Circuit. After the death of Antonin Scalia, the Fifth Circuit decision was affirmed by a 4-4 split decision from the Supreme Court that was issued in June of 2016 without an opinion. And so that's where we are. But note that at that time, DACA remains in effect. It was not part of the legal challenge to DAPA and the DACA expansion. And in fact, the lower court decisions distinguish DACA from DAPA and DACA Plus. So in January of 2017, Donald Trump comes into office after running on an explicitly anti-immigrant platform. And in November of 2017, then acting Secretary of Homeland Security Elaine Dukes announced that the administration would wind down the DACA program. And the reasons that the administration gave for the wind down were that the sole reason the administration gave for the wind down was that the program was illegal, or they believed the program to be illegal. So lawsuits were filed around the country, and DACA recipients were the most important litigants, telling their stories, as Dan said, in order to explain to the public the legality of the program, in order to explain the significance of the program in their lives. And they were important as litigants, not just telling their stories as people who were challenging the law, but also as lawyers. Luis Cortés Romero, himself a DACA recipient, is one of the lawyers working on the case. And so they were central to the litigation strategy. Judges in California and New York and DC enjoined the DACA rescission in early 2018, which meant that DACA recipients were still able to renew whenever their deferred action status was set to expire. It expires every 2 years. You have to pay again for an application every 2 years. But they were able to continue this renewal. What stopped was that new people were no longer coming into the program while this litigation worked its way through the court. And so the number of DACA recipients who are still in DACA status over the course of the past couple of years has actually declined. And then, as we all know, we get to the Supreme Court. Just this past week, we had the decision from the Supreme Court agreeing with the lower courts that the administration had violated the law in its attempts to rescind the Deferred Action for Childhood Arrival program in the way that it did. And so that's where we are now.
Thank you, Jennifer, for that terrific timeline. That brings us to the case itself. Hiroshi, would you be willing to talk for a couple of minutes about the case itself and tell us a little more about it? You're muted, so. Hiroshi, you need to unmute yourself. Hiroshi, we can't hear you. You need to unmute yourself.
Okay, you got me now?
Well
okay,
done, yes.
Okay, it's not easy to find a cursor here sometimes. Yeah, so thank you. Thanks all for being here today. And also I want to express my personal thanks to Alicia Manana. not just for her support for the Center for Immigration Law and Policy, but for her support also for the Immigrant Family Legal Clinic and for important initiatives in the law school over the years. We're really deeply appreciative of everything you've done. So in a sense, I have the easy job here, which is to summarize the decision from last week as opposed to 2 decades of developments. So the court addressed 2 challenges to the decision to rescind DACA. One was the rescission decision was arbitrary and capricious. That's a term of art. That if something is arbitrary capricious, it's against the law. It violates the Administrative Procedure Act. And the other challenge that the court was dealing with is that the rescission of DACA violated equal protection. It discriminated against Latinos. Those are the 2 claims. And there's a 5-4 decision with Chief Justice Roberts writing for the majority, joined by Justices Ginsburg, Breyer, Kagan, and Sotomayor. Although Justice Sotomayor, I'll explain in a minute, deviated on one important issue. And the consensus on the court was that the executive branch can end DACA, but the executive branch has to go about the right way. If it does, the courts won't second guess the agency decision. But the Administrative Procedure Act requires reasoned decision-making, and decisions that don't meet that standard are arbitrary, capricious, and they're invalid. And that's how the majority characterized this particular decision. In looking at the decision, I think the court did 3 important things to get to where it got to in the end. One is that to evaluate an agency's decision-making, you have to look at the justifications that the agency gave when they made the decision. You don't look at what the agency said later, and this is the reason that the court focused on a memo, often called the Duke memo, issued at the time of the rescission. So that's the first thing. What do you look at? The second thing is, the majority looked at DACA as having 2 important parts. One is that you're not enforcing immigration law. The court calls it the forbearance part of it. And the other is that DACA also provides eligibility for benefits under pre-existing law for Social Security, Medicare, and work permits. And the third thing the court did that was very crucial to the decision was that a lot of people have relied on DACA, not just 800,000 people who've had DACA, but also their families, their employers, educational institutions, really throughout American society. So what did the court do? First of all, it focused on the Duke memo, not anything that the agency said later, and said, look, to the DHS, it said, you relied on a judgment that granting benefits might have exceeded President Obama's authority. But you never really had a decision or even considered the fact that even if the benefits were unlawful, it's still okay not to enforce against people. You never considered that option, that you could have ended the benefits but continued reprieve from deportation. So you just didn't do something really basic. The second thing, and so that makes it enough to make the decision arbitrary and capricious. The other thing it did, or failed to do, independently sufficient to block the rescission, was that you, DHS, did not consider the reliance interests of the people who have over 8 years constructed their lives around the opportunities created by DACA. And you didn't consider them. In fact, you didn't even mention them. And so in short, the administration did not go through a complete decision-making process of the sort that's required to, as the court says, promote agency accountability. You have to explain why you do things, when you do them, and if you don't consider the basic elements of decision-making, then that violates the law. And that's the decision here, 5-4. It's important to note that the DACA recipients also made another argument, that the supporters of DACA made another argument against ending it, and that is that the ending decision to rescind was a discriminatory decision against Mexican and Latino immigrants. And only Justice Sotomayor would have let this decision continue on to get more fact-finding in the courts. And then you have dissenters suggesting either that DACA is illegal or that the record should look at not only at the reasons given when DACA was rescinded, but everything the agency said later. And those are rejected. So that's the quick summary of what the Supreme Court did last week.
Thanks so much to all three of you. So that focused on the case itself and where we are. We already have one question from the audience that follows directly, I think, from this, which is, does the administration have enough time to end DACA following the roadmap that the opinion laid out using the APA before the election? Could they do that? Or is that probably unrealistic? Does one of you want to take that?
I'm happy to start and happy to be corrected by any of my any of my fellow panelists if they disagree, because I think there is uncertainty in this area. So I think the answer to the question is it could be theoretically possible for the administration to sort of try to move through a process, give reasons, evaluate evidence, and provide a different grounded policy rationale for the revocation of DACA. So they do have some time. In dismissing the equal protection claim, in some ways, the court is suggesting that they're not going to be suspicious of that of that inquiry on equal protection or discrimination grounds, which I think is interesting in itself. So theoretically, I think they could do those things. And I am not one who's prepared to weigh what the administration is going to do. I've been wrong about that on multiple fronts throughout the kind of period of the Trump administration. I think one thing that is interesting to note, though, is even if they do that, it's not clear what the structure of any rescission that they then order would be. And so if you think back to 2017, when Elaine Dukes announced the rescission of the program, it wasn't an immediate cessation of the program. It was instead, it kind of gave a 6-month period for people to continue to renew. And then the idea was that after that, people would begin to fall out of the DACA program as their 2-year term expired, which means that the last people would still be in the program for as much as 2.5 years beyond the date of the announced rescission. So even if the administration moved very quickly, had new policy rationale, announced a rescission, it might well be that as a practical matter, nobody falls out of the DACA program during the remainder of the kind of the Trump administration, the first term Trump administration. So then the question would really hinge on who's next, right? Is there a new president, in which case there would be all kinds of opportunities for legislation around this issue, to creating pathways to citizenship for not only DACA recipients, but broader groups of people. There could be, a new administration could decide to keep DACA in place, although that might be subject to litigation challenges. So that could look very different if there's a new administration. If Trump continues to be president after the next election and the administration is committed to rescinding DACA, I think this Supreme Court has given them a green light to do that.
Thank you, Jennifer. I'd like now to ask about this sort of broader, DACA is one piece, obviously, of a broader set of immigration policies. Could a couple of you talk about that, either in terms of the upcoming presidential election and whether we should expect to see immigration policy playing a piece of that, or other frames for just how we think about DACA and its links to broader conceptions of immigration policy at this particular moment?
Well, I can start with something that I would have added in a sense, not as a correction, but to what Jennifer said, and that is that I think everything Jennifer Chacon, you laid out on what's coming is quite right. But I think a lot of what's been going on with the Trump administration is trying to limit its political accountability for rescinding DACA. One of the things that the administration did was blame it on the courts. And then the courts pushed back and said, don't blame it on us. You just didn't do it right. And so one obstacle, I suppose, or hesitation the administration may have is to try to rescind DACA is the political accountability that would come with it. DACA is a very popular program across a lot of otherwise polarizing lines, and so that's important. So that really gets to the question of the politics here. One of the things we've seen is that DACA recipients, dreamers, whatever term you want to use, have been used by the Trump administration actually to focus on the last 4 years to try to extract concessions. And to give you a specific example, This was back in the budget negotiations a few years ago. We had from the administration a willingness to go forward with some measure of protection for DACA recipients, but in exchange, the price would have been extracted from well, largely from Democrats in Congress, would be more support for border enforcement, for example, or for interior enforcement. And so one of the things we're seeing here is that the fate of legislation will depend heavily not just on an up or down, do you support Dreamers, do you not support Dreamers, but how it fits into so many different issues ranging from asylum to interior enforcement, not to mention a lot of restrictions on immigration. That's just one angle.
And if I may add on that, we have also seen as Dreamers have lost their fear of sharing their stories and taken an increasingly proactive role in speaking out about what future legislation should look like. We've heard great concern from Dreamers about the rest of their families and not wanting, in many Dreamer-led organizations, speaking out against legislation that would grant them a benefit while sacrificing future status opportunities for their parents or other family members. So I think their voice in where legislation lands is going to be critical.
Thank you. Yeah, no, that's incredibly important and powerful. What do you each see about sort of changing moods about immigration, especially on the southern border? Are you seeing shifts that you think affect the range of what's possible, or what might be more challenging? Any thoughts on that?
Well, go ahead.
No, please, Hiroshi.
Okay. Well, I mean, the situation is I think complicated by a couple of factors here. One is that we have a lot of people coming to the southern border, fleeing violence and horrible conditions, especially in Central America. That's created a number of situations that the Trump administration has responded to by trying to drastically cut back on asylum. Now, it cuts a couple different ways. I mean, one is that the arrival of a lot of people, I think, may create a situation where it becomes a favorable campaign issue to talk about tough enforcement. But the administration has done a couple things that have undermined that political intent, and one is that going so far as to separate children from families, and also doing things that I think completely disregard a lot of obligations the Congress adopted as far as protection. So I mean, I think that's one thing that complicates things quite a bit. The other thing, of course, is that we're in the middle of a pandemic, and what I'm seeing in the administration reminds me of what a well-known politician once said, which is never let a good crisis go to waste. And I think that the administration has seized upon this opportunity, in a sense, created by the pandemic, to do a lot of things that were always on its agenda. And again, this maybe is a broad way of illustrating how the fate of DACA, the fate of Dreamers, is tied up in a larger set of immigration issues, which is tied up in a larger set of economic and public health issues.
Jennifer or Dan, do you want to add anything further about that?
No, I think that I think I agree with Hiroshi's assessment. I think one thing that always complicates immigration conversations is an uncertain economy. So we're there right now. On the other hand, we also see, as Hiroshi pointed out, a lot of pushback against some of the administration's most aggressive moves in the immigration sphere, and that I think has created some space to bring some difficult issues that I think for a long time were unable to gain traction back into focus. And there's a real possibility in this moment for something meaningful to happen in the immigration space. That, of course, really turns on the election coming up. I think if there is no change of administration, I think we can rest pretty assured that what we see right now is what we're going to continue to get in the realm of immigration, and that is just a tendency toward increasingly restrictionist policies, both in terms of reduced avenues for immigration through visas, and also through crackdown in enforcement, both at the border and in the interior.
Thanks. I'd love to ask you, so the University of California is a part of this case, right? Explicitly and named, not standing alone. But the UC's been part of this story in a variety of ways. I'd love to hear any of you tell us a little bit more about that. The UC system's role and also just UC thinking even in going back to the beginnings of that.
Yeah, it's funny, as I was giving my timeline, Abel Valenzuela sent a note to the panelists to remind us of the role that UCLA undergraduate students really played in the early efforts to pressure the Obama administration to do something, and something that sort of ended in DACA. And so there was a very influential role that was played by students here. We saw it again with the litigation against the rescission. There were all kinds of people within the UC system who were sort of active in litigating those cases. We've seen both the UCs and the CSUs respond to the Deferred Action Program by creating legal service support systems within the university and college structures. And so I think by responding to DACA in a way that provides legal services, including legal services to family members, the university has really sort of built out support in some ways for these communities around the program in ways that have made it stickier and have sort of given an advocacy edge to people who are seeking to keep it in place. And so there has been, I think, a significant role on the part of the UCs, the CSUs, public universities in general. And more critically, there's been a huge role played by the students who in this space that has been created have sort of made the most out of a situation that I think is always tenuous, always perilous, always fraught, but have somehow managed to put that to the side in order to continue to pursue advocacy efforts on behalf of not only of themselves, but also, as Dan pointed out, on behalf of a broader community.
I'll never forget when, I think it was in 2010, when some students, including UCLA students, came to me in my office and said, Congress is stalled, but we have this idea. We've looked into this a little bit, and we think that the president can do something. Seems crazy, but we think maybe that can happen. What do you think about that? And so these are the small things that add up to quite a bit.
And to add on that, how that moment really invigorated the immigrants' rights movement. So, that really led the state of California to begin in making strategic investments in immigration legal services. As Professor Chacon mentioned, we have now this infrastructure on campuses, but also the number of direct immigration legal service providers has increased exponentially since 2014. For DACA beneficiaries and all immigrant communities as a result of what was initially a campaign to respond to what looked like was going to be this expanded DACA and DAPA program. And so, and then I think also seeing that in context, California from the time of statehood until the 1990s really led the nation in so far as xenophobic, anti-immigrant policies. And we really saw in the last 2 decades that pendulum swing dramatically, where it's now considered the leader in progressive welcoming legislation for immigrants. But that last push to really build up this robust immigration legal services infrastructure, initially to assist DACA beneficiaries, but now to provide representation to adults in removal proceedings, that momentum began around 2014. So the ripple effects of the Dreamer-led movement going back 2 decades have been enormous.
Thanks. I think that's really important context and great to understand. Dan, I'd love to come back to you for giving us a little bit more about the perspective from local government, where you are now. Can you tell us a little bit about all of this is playing out at so many levels, right? Local, state, and federal. Maybe you could talk to us about the perspective from the space you're in now, or how it looks different from when you were in your at CARECEN.
Well, I think there's a lot of overlap. I think that local government has an interest in, and the conversation about the value of immigrant communities has also transformed in the last couple decades, where it's no longer a question of whether immigrant communities are important. It's how should we be investing in their future, in their success here. And so we've seen, as I described, the state of California in 2014 or thereabouts, beginning to build out legal service infrastructure. We saw after the election, philanthropy, the County of Los Angeles and the City of Los Angeles come together to create this LA Justice Fund to provide legal representation to immigrants most at risk of removal, including people in detention centers, a conversation that in years past would have been unthinkable. So when I think back to being at CARECEN in 2005 and through 2010, those were not always easy times for immigrants. And the thought of state funding, local government funding to support immigrant communities was really unthinkable at that time. And so that conversation has transformed enormously to now where our office, the County Office of Immigrant Affairs, providing webinars and finding ways to connect not only Dreamers, but other immigrant communities to the full range of services that the county offers is a recognition that local government sees the value and sees its future as connected to immigrant communities. And we find ourselves in this COVID moment where there are questions about what economic recovery is going to look like. And I think it's very clear for people in this town that if immigrants aren't part of the conversation and if the recovery isn't frankly immigrant-led, it's probably not going to work very well. And so all of this is a very different moment than we were in 15 or so years ago.
Terrific, thank you. I want to make sure that we spend some time getting to some of the questions that we're getting. We're getting some excellent questions. And so I'm going to share some of those now for people to address. And if you want to keep, we won't be able to get to all the questions, but I do want to encourage audience members to feel free to submit questions. One of them takes us back to the opinion. Somebody's posted, can you tell us anything more about why the other judges dissented and what this means? So, Kavanaugh thinks that even though the administration didn't give a valid reason when they enacted the rescission, they did later, and that's good enough. Is there more to say about that in terms of how we think about the opinion and what's likely to happen? Or how do any of you think about those interpretations?
Well, we have Justice Kavanaugh's dissent, and as the question points out, his view is that it's wrong to hold the administration to the decisions, or to the justifications it gave for the decision at the time it made the decision. Justice Kavanaugh would look at a different memo that was issued quite a bit later in litigation, actually, to explain more fully what the administration is doing. But Chief Justice Roberts and the majority wouldn't have any of that. But I think Chief Justice Roberts was applying some standard administrative law, which is that we judge the propriety, the lawfulness of agency action based on the reasons they gave at the time. Justice Kavanaugh says that's just going to be a delay. You're just going to send it back to the administration, and they're just going to come back with the same decision. I'm not so sure that's true. Because the political calculations going into the decision now are going to be very different from blaming the courts. So the other dissent is from Justice Thomas, joined by Justices Gorsuch and Alito. And their view of this is, in a nutshell, that DACA is illegal. End of analysis. Because it's illegal, it should end. And so those are the two decisions that. The two sets of dissents. Alito adds on a comment about the political process and what happens when courts get involved. But yeah, so those are the dissents, somewhat different from each other, actually. And then, of course, I want to remind us again of Justice Sotomayor taking a different view. She would let the discrimination decision go forward, or discrimination claim go forward.
Right. Jennifer, do you want to add anything about Sotomayor's dissent or anything else in this respect?
just a couple of things. I think the one thing on the majority, I mean, I think what's interesting is, as Professor Motomura has just pointed out, you have 3 dissenters that say very clearly that they think the program is illegal. And the fact that we have 5 justices who didn't go down that road, including Justice Roberts, I think is really important in the way that it sort of situates and strengthens DACA. So there's a lot there in terms of giving this continued legitimacy, continued life. I think the Sotomayor partial dissent is really illuminating, although perhaps not surprising. We see we've sort of seen this before with many of the same justices. You remember just a few years ago when there was a challenge to the Muslim ban after the president made it the host of very sort of blatantly hostile statements and racist statements about Muslims, and the court declined to find that there was an equal protection problem in that case as well, that they just couldn't find the evidence of animus in the record. And so it's not surprising to see Justice Roberts, Justice Alito, Justice Gorsuch, Justice Thomas unable to find that evidence of animus in a record that includes statements from Donald Trump about Mexicans being rapists and murderers, and some of them he assumed were good people. But they couldn't find the animus in those statements that was sufficient to sort of connect up. It's not surprising given what they've done before. It is surprising to see Justice Ginsburg and Justice Kagan and Justice Breyer joining in that portion of the opinion. And I think that to me is perhaps the more distressing piece of this, because as Justice Sotomayor points out, the evidentiary bar is pretty low at this stage of the proceedings. And to toss it out and just say we don't have any evidence of animus, given kind of the level of toxic statements that were made, is somewhat surprising and distressing.
Thank you. We have a number of additional really good questions. So here's one about what if Biden is elected, do you have some predictions about immigration reform? What might be possible? How far could it go? Could we remedy some of these setbacks? Thoughts? Who wants to prognosticate?
I can go quickly and then
please.
let others go long. I guess I feel better about it now than I did maybe 2 months ago. I think this sort of national clamoring for racial justice, the sort of calling to account of institutions for their sort of perpetual inability to remedy racial discrimination against Black lives in this country has really been an important moment where people are taking seriously concerns about institutional and structural racism in ways that I think we haven't seen for a long time. And so I think that creates a potential moment for immigration policy and immigration reform to be evaluated in a different light, one that takes seriously concerns about equality, one that is kind of committed to a different vision of how the country should operate. And so in this way, as we've seen so many times, it has been the movement for Black lives, and before that, civil rights activism by African Americans, sort of really creating a space for a conversation that benefits so many other people as well. And so I think, I say this with gratitude as somebody who is a beneficiary of that sort of civil rights tradition, and I see that sort of space opening again. And so I think I have maybe more optimism about the imaginative potential of kind of what addressing our immigration problems will look like than I did probably 2 months ago.
Yeah, I think if I can add to that, a couple points that I think if you look back to 2006 and 7 and then 2013, where it really looked like comprehensive immigration reform was speeding towards passage, the assumption was that this had to be done in a big, massive bill that addressed all kinds of issues and needs in one package. I don't think that it is a certainty by any means that immigration reform will eventually happen in that way. It may happen in a more piecemeal approach. There is the downside to, from the perspective of the broader community, of addressing dreamers and then taking the energy for addressing their plight away from that of the community at large. But there are a number of other really important issues that haven't been addressed. We haven't discussed on the panel the plight of individuals who have temporary protected status from certain countries that have experienced a war or natural disaster. We have 300,000 of those individuals whose status is also at risk right now, many of whom have lived in the country for 20 years or more with work authorization. So there are a number of aspects that could be put together in one package, or that may be addressed in a piecemeal fashion, which is probably the more likely approach given the past failures to do something so big and complex.
Let me just add quickly, because I know we're running out of time. It's that I completely agree with the reworking of politics, of consciousness, and the opportunities it creates. And just one specific example of this is the contradiction that we are regarding essential work. We have undocumented workers who are regarded officially as essential. And this is the moment to recognize that there's something that completely is hypocritical about that. Another is the view that the system that has brought us to this position is a system that treats the countries from which people are coming, in many cases fleeing, quite unfairly. And this is the reason we have 10 million people in the country without papers, is that we have a policy that, in a sense, has invited them to come, and so that needs to be rethought. What I'm afraid of, although maybe this is not so much a fear as the limits of my optimism, is that to have a really sound immigration policy in this country needs to really rethink its relationships economically and in the larger sense with a lot of the world, starting but not only limited to Latin America. And those are the long-term solutions where the solutions really lie. And I'm not sure the moment is big enough for that, but I think it's big enough for a lot of things that have been a little bit beyond political possibility for the past generation.
That's great. I want to put one final question to you, because several people have been asking about this, which is about, in the wake after this opinion, what about new applications for DACA? Is the administration going to accept them? Do they need to? And would you recommend that somebody try to file now, even before there's clarity about that? How would you suggest concretely people proceed, and what do we know about that?
So I guess I'll go first on that. I think it's very clear the 2012 program is now in place as it stood prior to the litigation. And so while the administration hasn't put out guidance on new applications, from a strict reading of the decision, the program remains in place. And that includes both new applications for individuals who've aged into the program or otherwise meet the eligibility criteria, and then potentially the issue of advanced parole, a benefit that was also provided travel permission to come back into the country lawfully. There are obviously issues there around COVID and travel now, but I think the administration would be hard-pressed to deny applications at this point. Whether they process them immediately or sit on them for a period of time, I think is an open question.
I agree with that. I just wanted to flag that the day after the decision was handed down, Acting Deputy Secretary Ken Cuccinelli of the Department of Homeland Security made a statement where he said, quote, "The Supreme Court's decision is an affront to the rule of law and gives presidents power to expend discretionary policies into future administrations." And I just found that statement really striking, that the agency that is charged with the processing of these applications is sort of saying that the Supreme Court decision interpreting a statute is at odds with the rule of law. So it was maybe the not so deep state, an acting official, never Senate confirmed, making this sort of shocking statement about how to understand and think about the Supreme Court decision. And so that's the piece that is always the makes people nervous, I think, when they're turning over their information and putting their lives into the hands of this administration. Their sort of overt hostility to the rule of law in this context, I think, makes it a stickier sort of situation than you would generally expect it to be, where it should be quite straightforward. this is what this report has said, the program is in effect, you should file if you are eligible. That should all be quite straightforward. But I think it's statements like that that are quite deliberately designed to instill fear and that give everybody questions about the good faith with which applications will be processed.
Thank you. That's a slightly disheartening note on which to end, but it's also a bit of realism. No, I'm really grateful to our panelists today and to those of you who've attended. Thank you for being with us. I want to just conclude with a couple of concluding remarks. One is that I hope you'll continue to be involved as the activities at this center do grow. We have several other faculty here at UCLA Law School, including Ingrid Eagley and Nina Rabin, who focus squarely on immigration. And all across UCLA, there's really a tremendous number of faculty for whom this is a really central focus, and I think that's so critical. I also wanted to say to you that we have several other upcoming events that I hope you'll consider tuning in for. The week of July 6th, we're actually going to have two conversations about race and racism. Our Critical Race Studies program is putting together a tremendous lineup for a lunchtime conversation on July 7th. And then on July 9th, we will also have a conversation about policing, and I hope that some of you will join us for those as well. So thanks very much for being here today, and please join me in thanking the panelists for spending their time and expertise and sharing their thoughts on this very important case. Take care, everybody, and stay safe.